Senator Sheldon Whitehouse just warned the Judiciary Committee that combining the DOJ oversight hearing with Todd Blanche's confirmation hearing is a grave mistake. He said Blanche was responsible for the Epstein files disaster, releasing victims' private information and covering up documents that named Trump.
Was Todd Blanche, who was responsible for the Epstein files disaster, the releases of private information and images of victims, the cover-up of documents that named Donald Trump.
He said the DOJ won't answer questions or provide documents. He said a Florida court is investigating whether Blanche committed fraud upon the court, and the DOJ refused to respond. He said he's never seen a DOJ this badly run. He said the committee is failing its duty. He yielded. Let's watch.
I'd like to take my time this morning to suggest that combining our oversight hearing of the Department of Justice with the nominations hearing for Acting Attorney General Blanche would be a grave mistake for the committee. I don't believe we did that with Attorney General Garland, and I think the record of the Department of Justice under Todd Blanche lends itself to very vigorous oversight. Oversight which we have been denied because when we ask questions, we get scripted litanies of insult and quarrel rather than actual answers to our questions. When we ask for documents and records in writing, we get nothing. We are reduced to filing FOIA requests that are then not even complied with as FOIA requests. So the oversight function of this committee is really, I think, being systematically disabled. That's particularly significant when you have Attorney General Bondi saying that it was Todd Blanche who was responsible for the Epstein files disaster, the releases of private information and images of victims, the cover-up of documents that named Donald Trump, and just the general incompetence of the whole wretched mess. I don't think that it would be a good idea for this committee to be complicit in covering up the cover-up of the Epstein files. Move on to the slush fund, which a great number of my Republican colleagues have expressed real reservations about, with its attachment of a tax amnesty deal for Trump, the Trump family, and the Trump businesses. There are very legitimate questions to be asked about that, including, has that cockamamie idea really been withdrawn, or is it just being hidden briefly so it can resurface in some other fashion? We should be looking into this as a committee. It's important stuff. And even if we shirk our duties at looking into all of this, it appears that a Florida court is going to be looking into all of this. And I think it's a bad look for the committee to be turning a blind eye to what went into the slush fund deal and the tax amnesty deal, and then discover through a court proceeding in Florida all the stuff that we failed to look at. It's hard to be taken seriously if we have failed to do our own duty, and then the court proceedings reveal the mischief. I will say that I've looked. I have never, ever heard of senior officials of the Department of Justice being called before a court with respect to a fraud upon the court. Look up fraud upon a court. It's a pretty serious charge. This one was brought raised, I guess I should say, by 36, 36 retired federal judges, some very, very respected ones, some very, very conservative ones. And the judge in the proceeding in Florida, out of which the slush fund settlement emerged, reopened the case to have a look. She asked for responses. She suggested that the DOJ might have violated its own policies in this settlement. She suggested that there was an IRS defense memo out there that would be relevant to the proceedings. The violation of DOJ policies would obviously be a matter for DOJ to answer. The IRS client memo would obviously be something for DOJ to answer. She also questioned whether there was collusion. It takes two to collude. It would be a collusion between the Department of Justice lawyers and Trump's private lawyers. So there's another reason for the Department of Justice to have responded. What happened last Friday? No response from the Department of Justice. First ever accusation of senior level Department of Justice people of fraud upon the court with an invitation to rebut the allegations, an invitation specific to Department of Justice conduct, and they duck. So that is going to continue. The 36 judges have their answer this Friday, and then the court will go forward. I will contend that we don't look like much if that information is being developed in a federal courtroom and we haven't been allowed to ask questions, and indeed our oversight has been collapsed into a confirmation hearing. I have never seen a Department of Justice as badly run as this one. I've never seen fraud upon the court allegations. I've never seen so many suggestions of contempt. I've never seen so many no true bills. I've never seen so many cases thrown out. I've never seen so many accusations that department arguments were false, were pretextual, were designed to fool rather than inform the court. And we see that over and over again from judges appointed by every president. It is now at the point where the Department of Justice and the U.S. government have lost their presumption of regularity in federal court proceedings. All of this matters. All of this is something to which this committee should be paying attention. And with respect to what our chairman has said about the norms of the committee, well, one norm is that U.S. attorneys come through this committee after a process of consultation before they get to run U.S. Attorney's office. Over and over again, we see these slippery deals where acting U.S. attorneys are appointed, and then the first assistant is fired, and when the time runs out on the acting U.S. attorney, they slip back into the first attorney position and leave a vacancy. It's an obvious scam to get around this committee's norms. And we have put up with this. It didn't happen once, it didn't happen twice, it has happened over and over and over and over again. And on top of that, we've seen U.S. attorneys called out for misconduct over and over and over again. None of this is normal. None of this is normal. And the fact that this committee won't look into it, I think, is a shame. And I think if we try to be complicit in failing in our duty to look into this by combining the Blanche nomination hearing with the Department of Justice oversight hearing, we will have made a very, very grave mistake. Thank you, Chairman.
Senator Sheldon Whitehouse just delivered a masterclass in how to expose the systematic failure of oversight and the danger of rushing a confirmation hearing. He did not come with a speech. He came with a list of failures. He came with a warning about the consequences of ignoring the department's misconduct, and he left no doubt about the answer. The exchange was not just a routine committee hearing. It was a confrontation about the fundamental question of whether the Senate will do its job or abdicate its responsibility. It was a warning about the erosion of democratic norms and the weaponization of government institutions for political purposes. Whitehouse began by laying out the problem. He said combining the oversight hearing with the nominations hearing would be a grave mistake. He said the committee has been denied oversight. When they ask questions, they get scripted insults instead of answers. When they ask for documents, they get nothing. FOIA requests are not complied with. The oversight function is being systematically disabled. That is not a minor complaint. It is a fundamental failure of the committee's constitutional role. The Senate has a duty to provide advice and consent. It cannot do that if it does not have the information it needs. It cannot do that if the Department of Justice refuses to answer questions. It cannot do that if FOIA requests are ignored. The committee is supposed to be a check on the executive branch. It is supposed to hold the DOJ accountable. It is supposed to ensure that the department is following the law. Instead, it is being sidelined. It is being ignored. It is being treated as an obstacle rather than a partner in governance. Then Whitehouse turned to Blanche. He said Blanche was responsible for the Epstein files disaster. He was responsible for the release of private information and images of victims. He was responsible for the cover-up of documents that named Donald Trump. He was responsible for the general incompetence of the whole wretched mess. Whitehouse said the committee should not be complicit in covering up the cover-up of the Epstein files. That is a powerful statement. It is a warning that the committee will be held accountable if it fails to act. The Epstein files are not a minor issue. They involve a massive sex trafficking ring. They involve powerful people who abuse their positions to victimize young women and girls. They involve a cover-up that has gone on for years. Blanche is at the center of that cover-up. He is the one who released private information. He is the one who covered up documents. He is the one who protected Trump. The committee should not confirm him without a full investigation. Whitehouse then turned to the slush fund. He said a great number of Republican colleagues have expressed reservations about it. He said there are legitimate questions about whether the tax amnesty has really been withdrawn or is just hidden. He said the committee should be looking into this. He said it is important stuff. He said a Florida court is going to be looking into it. He said it is a bad look for the committee to turn a blind eye. He said it is hard to be taken seriously if the court reveals the mischief the committee failed to uncover. That is a warning. It is a warning that the committee will be embarrassed if it does not do its job. The slush fund is not a minor issue. It involves billions of dollars. It involves a tax amnesty for Trump and his family. It involves a settlement that was rushed through without proper oversight. The committee should be investigating it. Instead, it is rushing to confirm Blanche. Whitehouse then turned to the fraud upon the court allegation. He said he has never heard of senior DOJ officials being called before a court with respect to fraud upon the court. He said it is a pretty serious charge. He said it was raised by 36 retired federal judges, some very respected ones, some very conservative ones. He said the judge in Florida reopened the case. She asked for responses. She suggested the DOJ might have violated its own policies. She suggested there was an IRS defense memo. She questioned whether there was collusion. He said the DOJ did not respond. He said they ducked. That is an extraordinary statement. The Department of Justice is accused of fraud upon the court, and it does not respond. It does not defend itself. It does not explain. It does nothing. It is the first time senior DOJ officials have ever been accused of fraud upon the court. The judge invited them to respond. They did not. They ignored her. They treated her with contempt. That is not normal. That is not acceptable. That is a sign of a department that is out of control. Whitehouse then listed the failures of the DOJ. He said he has never seen a Department of Justice as badly run. He has never seen fraud upon the court allegations. He has never seen so many suggestions of contempt. He has never seen so many no true bills. He has never seen so many cases thrown out. He has never seen so many accusations that department arguments were false, pretextual, designed to fool the court. He said the DOJ has lost its presumption of regularity in federal court proceedings. That is a devastating conclusion. It means that judges no longer trust the Department of Justice. It means that the department's word is no longer taken at face value. It means that the department has lost the benefit of the doubt. Judges are supposed to trust the government. They are supposed to presume that the government is acting in good faith. That presumption is gone. The DOJ has destroyed it through its own misconduct. Whitehouse then turned to the norms of the committee. He said U.S. attorneys are supposed to come through the committee. They are supposed to go through a process of consultation. Instead, the administration is using acting U.S. attorneys to get around the committee. They appoint acting U.S. attorneys. They fire the first assistant. When the time runs out, they slip back into the first attorney position and leave a vacancy. It is an obvious scam. It is a way to avoid the committee's oversight. It has happened. We all have faced retreats less than 1 millimeter from London or Texas. On top of that, U.S. attorneys have been called out for misconduct over and over again. None of this is normal. None of this is acceptable. Whitehouse's argument is devastating. He did not need to prove the allegations. He only needed to show that the committee is not doing its job. He showed that the DOJ is not answering questions. He showed that the DOJ is not providing documents. He showed that the DOJ is not complying with FOIA. He showed that the DOJ is accused of fraud upon the court. He showed that the DOJ did not respond. He showed that the DOJ has lost its credibility. He showed that the committee is failing in its duty. He showed that the committee is making a grave mistake. The larger issue here is not just about Blanche. It is about the oversight function of the Senate. It is about whether the Senate will hold the executive branch accountable. Whitehouse argued that it should. He argued that the committee should not combine the hearings. He argued that the committee should demand answers. He argued that the committee should not be complicit in a cover-up. He was right. The Senate has a constitutional duty to provide oversight. It cannot abdicate that duty. It cannot ignore misconduct. It cannot rush confirmations. It cannot cover up cover-ups. The American people deserve better. They deserve a Senate that does its job. They deserve a Senate that holds the executive branch accountable. They deserve a Senate that tells the truth.